Just turning the recording on now. So this is LAWS 12066 land law, and this is the tutorial on social housing, which is actually topic 8 in the unit as we're travelling through the topics, but we are in week 10. I think that's right, week 10. So folks, we're getting towards the end of our long journey through property and land law. Okay, it's hard to imagine that we started our journey back in March, isn't it, really? And here we are in the middle of, or the third week of September. And it's been a long journey, I know. And but hopefully it's been an interesting journey for you. And been a range of topics and material which we've traversed in a range of ways. The land law course traditionally tends to focus on those areas of law which have been developed in relation to private interests in land, whether it's about ownership or whether it's about rights, or whether it's about transactions, or whether it's about security interests. Last topic on the unit is mortgages, that's security interests. But essentially around private interests, okay? And private rights with regard to privately held land. Much of the traversing of land law is traditionally about that. This topic is different, and it is a bit of a novel feature. You know, I like to throw in some different things from time to time for my students, but it's not that it's just novel, but it's actually, in my view, and I think this is there's a growing consensus of this position, that it is becoming, if it's not fair to say it's already become, an important area of rights and responsibilities that law students need to be aware of and be conscious of. And what we're talking about here is that area that is involved with people in the society who are in circumstances of social or economic disadvantage. In some issues, there might be cultural dimensions as well. So social housing, community housing, government assisted housing. There are specific programs for Indigenous Australians, and we're not particularly focusing on those, but there are particular programs for Indigenous Australians. This area of land law, and you might say, well, is that really a land law type topic, Michael? Isn't it more something like, you know, social justice and other sorts of things? Well, it has a far-reaching impact, but it's essentially about the housing, accommodation, and property rights that are a part of providing housing options to members of the community who are socially and economically disadvantaged. Now, historically, of course, people in those circumstances, and of course we're talking about for purposes of habitation, for purposes of living, not for running businesses and so on. These folks, members of the community, ownership wasn't an option, okay? They don't have access to resources to own freehold, so that was an option. They're also challenged for a range of reasons to even access private rental accommodation. We saw in the topic on leases that it's a short section at the end there. We didn't spend much time on it, but I just alerted you to the residential tenancies legislation in Queensland, which is the Residential Tenancy and Rooming Accommodation Act, and that actually is relevant here, but we're actually focusing more on the environment of the provision of social community and affordable housing the providers that provide that housing, the legal frameworks around the regulation of the provision of that housing and those that provide the housing, and getting a bit of an understanding of the balance of rights and responsibilities. And the picture's a bit complicated because even though we're talking about the ultimate, if you like, the ultimate consumers, that is those that are being housed at the end of the day in circumstances of economic or social disadvantage or challenge, being tenants under residential tenancy agreements, there's sort of three players in the scheme. So you've got your ultimate tenants who are either in community housing or social housing, public housing. Notice it's interesting, we talk in this environment about housing, but in the context of the private sphere, we don't talk about, in terms of circumstances of becoming owners, we don't talk about house ownership, do we? We talk about home ownership. Home ownership versus public and social and community housing. We don't talk about community homes, public homes. It's quite interesting because there's a lot of power in language, as we know, and there's a lot of symbolism there as well. So that's interesting. But so we've got the ultimate tenants. We've got significant involvement by government, both federal government or the Commonwealth government and state government. So in Queensland, that's the state government through the relevant government agency. And at the Commonwealth level, we've got the Commonwealth agency involved. And the Commonwealth essentially is involved in terms of providing housing assistance by channeling funding in the direction of housing assistance. And you will have seen from my lecture that I've made reference, and I'm going to show you a couple other things tonight in relation to the reviews that are done by the Productivity Commission and the Australian Institute of Health and Welfare, which issue reports annually around housing assistance. And they document, and one of your colleagues has put up the most recent 2019 government service report on Moodle. I previously referred to earlier versions, including I think 2018, that document the range of government assistance. Essentially, the Commonwealth is funneling money into this sector, and that money is often, or historically, went to state government agencies for the purposes of managing managing housing stock, so purchasing dwellings or maintaining existing dwellings, and also providing financial assistance to organisations that then managed stock on behalf of the government, or indeed financial assistance ultimately flowing down to tenants. And then in the middle, we had an emergence of community-based organisations, which in time became identified as community housing providers, that were responsible for managing stock, housing stock, on behalf of normally state government. The title of these properties, public housing properties, was in the name of the relevant agency of the state government. Right? But something that's occurred over time is, in some places, the opportunity for these community housing organisations to actually acquire title to these properties, initially public housing properties, but with changing financial arrangements to actually, through being able to get access to more private finance, to actually purchase properties. And then what's occurred is we've got now a more diverse picture where we've got community and social housing clearly targeting those in circumstances, that is ultimate tenants, of social and economic and sometimes cultural disadvantage in the community. We've now got this evolving space of what's referred to as affordable housing, which is actually mechanisms that the government of the day and the involvement of state agencies and sometimes also community housing organisations getting involved in this, to provide different housing options for people that are sort of members of the community that are sort of getting caught in the middle, in a sense. So they're not actually in circumstances of significant social or economic disadvantage, but they're also not actually able to access the other options that are traditionally available. Now, what are examples of these sort of people? These people that are providing essential services to the community, so like police, emergency service people, school teachers, who are on fixed salaries, often not hugely significant, unless they're at the very higher upper echelons of those organisations, but if they're just the foot soldiers, not hugely significant salaries. And yet they are required to be in different locations because of their jobs. Nurses, another example of that, right? They're required to be in different locations. And some of those locations they're required to be in require them to actually be in a place that's fairly expensive to live in. And they actually find it very challenging in their income levels to access the conventional options of purchase or private rental, purely private rental, in the property environment that we inhabit today, where there's been a big escalation in both purchase price and also in terms of even rental accommodation. So these are the sort of members of the community that affordable housing programs are seeking to reach out to and provide other options for through different mechanisms of government systems. So what I'm saying is that the landscape is a bit more diverse today than it was when these assistance programs started. We've seen from my notes and from the lecture that all of this strategy really started post-World War II with the 1945, the first Commonwealth State Housing Agreement by the Chifley Commonwealth Government in 1945, which was a 10-year program, and it was a public housing program. Over time, that morphed into more welfare-type housing, and that also then led to other types of specific programs, including community housing and so on, specific programs for Indigenous Australians and whatever. Historically, there's a background in terms of community housing actually coming out of, members of the community, particularly females, who were often victims of domestic violence and nowhere to go, not adequate options when they had to get out of difficult situations, living situations. And that was really what gave birth to these community organisations that started meeting that need initially, but then discovered that there was greater need going forward. But it still has a significant role to play in that environment. Now, before we get on to the questions, I just want to share with you a few resources, basically, to give you a bit of guidance. You've seen my lecture and I've shared various things, so I just want to share them again here. A couple of reasons. So for the benefit of those that aren't able to attend tonight, firstly, but also for your benefit. Secondly, you know that this is a topic on the exam, okay? I've already told you that. I've told you where it sits on the exam. It's in part A, which is in the policy side of the equation. And you're going to, if you go, and you've got a couple of options there, as you know, from the instructions. If you're going to think about doing this question on the exam, then you're going to need to dig into some of this environment and some of the materials that I'm putting before you. All of it is, I'm not giving you anything more than is already on the Moodle website and already in my notes and whatever, right? A couple of updates, I suppose, from what was originally in my notes, but there you go. And the questions will be a bit more challenging than they were, for example, in the Term 1 unit, okay? That will be reflected in a slightly higher mark allocation, and that will be then, should correlate with you providing an appropriate more time with regard to the policy question that you choose. And it will require you to give thought to something emerging out of the topic in the context of current developments, reforms, initiatives, policy developments that you have been brought to your attention. Okay, so I'm just going to share a couple of things with you to start with, start the ball rolling. What is the first thing I want to share? Right. There we go. So the first thing I want to share with you is this document, which is the Queensland Housing Strategy 2017-2027. That is the update, current Queensland policy on housing, okay? Now my notes refer to an earlier version, okay, but I've updated that on the website. I've given you this document is on the Moodle website for topic 8, okay? And it's just interesting. It gives you a bit of a snapshot of the situation and looks at, affordable housing and different types of housing assistance that Queensland is focusing on, and strategies, government, non-government, private sector, and so on, okay? So you can have a look at that, all right? That's something that, see how that might be relevant in the context of what we're talking about. Right, so really encourage you to have a look at that document. What else do I want to show you? Just stop screen sharing that for a moment. And next thing I want to show you is, right, so the next thing I want to show you is, this is the website for the federal government agency dealing with housing assistance, which is today the Department of Social Services. Now, there used to be a Department of Housing all the way back when we had the first CSHA, but over time, government departments reorganised themselves, the focus of governments change. Conservative governments tend to have less focus on these sorts of things than Labor governments. They still provide funding, but they sort of channel it in different ways. Labor governments tend to be about more and bigger government. Conservative governments tend to be about smaller government and people getting on and doing things themselves and so on. So you can have a look at that and you can see there that it has a range of things, an increasing focus on affordability and then a range of schemes there you can see that you can have a look at. So I'll just stop screen sharing that for a moment. Right, so next thing I want to screen share with you is, so here we have the website for Queensland Agency, okay? So you can see that this is the housing and this is the hyperlink within Queensland Government for public and community housing, okay? So from the Queensland Government homepage, you can see the link there on screen up in the URL box, and then you can just go in and have a look at information here, and the focus is maybe public housing, community housing, and so on. We're not, as I said, we're not so concerned with Indigenous housing for Indigenous Australians, but you can have a look at that by all means and familiarise yourself with that. Right, so just stop screen sharing that. And I now want to just show you a couple of things by way, and this is actually what takes us a little bit into materials that are relevant for the questions. So we've got legal frameworks that we need to be mindful of. Okay, so we've got in Queensland, the Housing Act 2003, and that was amended by legislation that incorporated Part 4A. The Housing Act deals with a range of things, not just community and social housing, but under Part 4A, it deals with community housing providers, and essentially it's incorporating the Community Housing National Law insofar as that is incorporated into the Housing Act for Queensland. And that's about basically setting up a regulatory environment for community housing in Queensland underpinned by legislation. Okay. Now, I just want to come across to the situation in New South Wales, because what New South Wales has is at the end of its act. So in Queensland, what happened was the legislators or the government decided to incorporate provisions around the Community Housing Providers National Law. This is actually an appendix to the New South Wales legislation, which I'll explain in a moment. So that this national law came out of, it's not federal legislation, but it came out of basically a cooperative, an agreement between the housing ministers of the different jurisdictions, states and territories, came together and decided we're going to have a national umbrella law to deal with how we better structure the sector, introduce a regulatory framework for providers, and so on, okay, with a focus on tightening up various things and giving better outcomes for ultimate tenants. Now, the Community Housing Providers National Law, which is an appendix to the New South Wales Act, you can see, dealing with a range of matters, definitions, looking at setting up a registration system, and defining the powers of the registrar, and so on, okay? Dealing with a range of matters there, okay? Now, Queensland has implemented that as far as it has in Part 4A of the Housing Act. Other jurisdictions have done that as well, but not every jurisdiction has enacted as local legislation the national law, okay? But New South Wales was a bit groundbreaking because it started the process, and unlike amending its Housing Act, it has a Housing Act too, it actually enacted unique legislation. So it enacted, this is in New South Wales, the Community Housing Providers Adoption National Law Act in 2012, as separate legislation. And it had, a range of matters in it that went in some respects beyond what the national law provided for. And not all jurisdictions have made provision for this. I mean, one example is very interesting in Division 3, the vesting of housing agency land in registered community housing providers. This is the opportunity for community housing organisations to actually obtain legal title or land title in what were previously public housing properties. And there's also mechanisms for mortgages and to secure the public interest and so on. But that was a bit of a game changer in some respects, even though not everyone in the sector thinks it was as much of a game changer as it probably should have been. So there's that. And that's what I wanted to show you. That's all for the time being. So I'll just stop screen sharing that. So there's a range of resources there. And this is a topic where you need to think about the way in which legislation, government regulation, and government policy is impacting to affect the rights and responsibilities of participants and stakeholders. And in particular, you're thinking about the role of government, you're thinking about the role of those that are managing housing stock, community organisations, and you're thinking about the ultimate benefit for tenants at the end of the day, those that are being housed. That's what it's all about, housing people that can't otherwise get access to accommodation. Okay, so let's go then back to the questions that I've posed for tonight's shoot. And those questions are, firstly, explain how community housing is different to public housing. Is all government assisted housing other than public housing best described as community housing? That's the first question. And then the second one is, what are the benefits of the enactment of the Community Housing Providers National Law? Explain the relationship between the Community Housing Providers National Law and the Housing and Other Legislation Amendment. Well, that really is now the Housing Act 2003, where that amendment has been incorporated into the Queensland Housing Act. So what's the relationship between those? And what's the benefit of the national law? All right, so the first question is basically looking at this difference between community housing and public housing. And when we're talking about government assistance, are we talking always about just those forms of housing? Okay, so I'm just going to stop screen sharing that. So how would you like to do this? Would you like to, how many of us are there? It's only 8. Oh, it's not really worth breaking into small groups. We're already a small group. So how about we start like this? What I might do is a little exercise, a little sort of primer exercise. Just put in the chat box, firstly, what comes to mind when you think of public housing? What other words do you associate with the phrase public housing? Just whatever comes to you, whatever you think of. Housing Commission. That's, you know, I just want to pick up on that one because it's interesting that phrase, Housing Commission, out there in popular land, if we can call it that, popular people land out there in the world, that is a phrase that still resonates. If you mention Housing Commission, there's a lot of people in the community, oh yeah, I know what that means. That means housing for people that can't otherwise buy their own home or whatever. But the interesting thing is that the Housing Commission, which actually did exist, right, and it actually comes from that phraseology comes from the body that was originally created after the first Commonwealth State Housing Agreement in 1945, and in particular, in New South Wales, the body that was administering it in New South Wales Court was called the Housing Commission. But the Housing Commission ceased to exist decades ago. It actually became the Department of Housing, and in several jurisdictions they had at state level departments of housing. But even that, they've disappeared. As you've seen, there's no longer...
It's an age thing, Michael.
Sorry?
It's an age thing.
It's not... You mean, when you say age, do you mean in terms of... what?
No, it's my age.
Well, that's an interesting comment, Peter, because what I want to reflect is that actually it's not. It's a cultural thing. So it's not just people of a certain generation. You can ask a lot of people and they will still identify this phrase, Housing Commission. And they will, you know, so it's really interesting. It's got locked in the psyche. And so it's interesting, your comments there about, you know, yes, several of those features. You can even be a private freeholder and have a 5-row home, of course. It's not isolated just to that. And in fact, most dwellings, public housing dwellings today aren't like that. But some of them are in sort of, or did emerge as sort of almost like ghettoised environments, which then had a lot of social issues because they basically, public housing became welfare housing, where most of the tenants were also dependent on benefit from government in various ways. And then now there's been a big strategy to transform that. If I mention the phrase community housing, what comes to mind then? What do you think of community housing? Yep. Yep. The reality, folks, here is that we actually end up with a variety of definitions coming from different places, and you can see that, you know, go to the government service reports, there's definitions, go to the Australian Institute of Housing and Welfare, there's definitions. We can even come back to the Queensland legislation. got a definition here. Or maybe if we go to the national law, we might get one better. Okay, so let me show you this. So here is, let's share this with you. All right, so we're going back to the Community Housing National Law, which is an appendix within the New South Wales Act. Okay, it's a bit different than the Queensland Act. So you can see there under Section 4 definition sub 1, community housing means housing for people on very low or moderate income, or for people with additional needs that is delivered by non-government organisations. It's pretty vague, isn't it? You know, low, very low, low or moderate. What does that mean? You know, what, not $800,000 a year or more than $8 a year, or very vague. And that's in legislation, right? So it's not very precise. And yet you can go to maybe a government service report or a government policy document that gives a different angle on what do we mean. Essentially, I'll just stop screen sharing that. Essentially what we have at the end of the day is we have housing that is being provided to people. I tend to use this phrase, those of social and economic disadvantage, because I think that's it's both more generic, but it's also a bit more precise than low, moderate income. It's being managed by a community-based organisation that's grown out of grassroots community response to issues and problems, but not only managed. So today, in some jurisdictions, there are options for those organisations to actually own title. And then in the affordable housing space, and even in the social housing space, there is now opportunities also for different types of co-ownership options or possibilities are being explored. So we've already looked at the idea of co-ownership, right? But co-ownership, the land law governing co-ownership, has almost entirely, as you've seen from the material that you've read and thought about, has been about private individuals owning together. Well, what about a private individual being a co-owner with a government agency? That is now another option that's being explored to open up other possible accommodation and housing options for people that aren't in positions where they can actually directly get involved in the housing market in the way that historically was maybe more the case.
That makes more sense too, doesn't it, generally, Michael? Because I think if you give people a vested interest in something, number one, they're going to look after it more than just if it's housing that's given to them at a subsidised rate, because they have an investment in the property, which means there's an investment in their local community. And it's interesting in the point you were mentioning before that the National Rental Affordability Scheme itself is now embedded into the Income Tax Assessment Act, which means that people are being derived by their income table status, which sets the income amount that their net worth status per year as to which bracket they fit into to qualify for these programs. Yeah.
No, that's absolutely right, Nicholas. And that's part of what's driving these initiatives. And I also noticed that Peter's referring to the situation in Britain and co-ops. Yeah, now that's interesting because co-ops and the sector in the UK is actually quite strong because there's large numbers, okay? If you have a look at the documents, you have a look at the policy statements in Australia, the numbers are still relatively small. You might have seen my slide. I shared an infographic from one of the recent, I think it was a Productivity Commission reports a couple of years ago. We're not talking about a tiny number. I mean, I think the number of dwellings is about nearly 900,000, and the number of community housing tenants is about 500,000. Right, well, we've got a population in Australia of 24, 25 million, right? But they're not all, owners. They're not, the households are different to numbers of members of the community. So it's not zero, but in my, and this is a field of research of mine and interest academically and practically. When I'd written substantially about this a few years ago, it was still, community housing was still less than 1% of the total land tenure across the Australian landscape. So we're not talking about huge in terms of extent of coverage, but of course it's a significant number of people within that percentage range that are involved in this situation. So we've had those different options. And the other thing that's, an thing that I'm interested in is how more conventional or traditional mechanisms that have been used in property law can leverage into this environment to create other opportunities and new options for people going forward that maybe haven't always been there. Now, the other part of this question, right, so the difference between public housing and community housing, essentially public housing means that housing that is owned by the government and managed by the government to provide housing to tenants who can't otherwise access other forms of accommodation. And often it's characterised by management by large bureaucracies, right? But there's been in recent times appealing back from that, realising that those large bureaucracies can't actually do that optimally. And there's problems and issues there. And the other thing that's occurred is huge waiting lists to access public housing, sometimes up to 10 years. It's just unbelievable. Can't access it, can't get into it. And then once people get in public housing, they basically can stay for a long period of time, but there's been changes to that as well, okay? So community housing is much more in touch with the tenants. It's managed by community organisations, and it's an alternative to public housing to basically respond to many of the problems and issues that arose in the public housing type environment. The last part of this question asks, is all government assisted housing other than public housing best described as community housing? What do you think? Is all government assisted housing that isn't public housing best described as community housing?
I don't know about that one. I've been reading some of the material today. I may suggest that the answer would be no, because there's programs in there like the home purchase assistance package and the first home owners grant and things like that. So they don't actually come into community housing as in a physical house. It seems to be programs to help people get into or acquire a house as well.
Look, anyone else? Any other thoughts?
Michael, I don't think that it is, because government assistance can be given in the private rental market, as Nicholas says. It can also be given for first home buyers and that type of thing. So I don't think it's all community housing. No, that's a different kettle of fish.
Yeah, no, that's useful. And so the statement is a bit too much overreach, isn't it? That's really, I think, what you're saying. Now here's a little, what am I going to call this? Michael's hot tips. Should I call this Michael's hot tips? Maybe I should. Be careful about overreach, folks, in statements. Be careful about overreach. If we wake up in the morning and the sky is orange, just because Michael says the sky is orange, no, the sky is not all orange necessarily, right? So, point is, moral of the story is, scrutinise what's before you carefully. Scrutinise the statement carefully. Don't make assumptions, and don't just go along easily with the flow of the statement. There could be a few traps along the way in the statement, okay? Could be leading you up the garden path a little bit, right? To see where you might either fall off the edge or stay on the road, right? So I think, and I like the points that have been made, and I think, is anyone else proffering a view? Yeah, it's a bit overreach to say that it's all community housing. Well, I think a better response would be to say that, well, community housing is evolving. So a bit more of an insightful response. It's evolving, and it started in the way that it did, as I've suggested historically, but it's evolving, and it's embracing a larger environment with other options and possibilities, and maybe, you know, community housing organisations working in the affordable housing space and reaching out to this other type of group or collection within the community which can't access traditional housing options. But to say that everything other than public housing is community housing is really, I think, it's too much overreach. But it's important when you're challenging those statements that are before you to give evidence to support what you have to say. One of the things that I've been seeing in the assignment, in the second assignment, for example, I'll just make a comment here. In the you know, people sometimes think that the essay, in quotes, or what I call policy questions, I think they think it's the soft landing, right? Oh, just if I write about stuff, that's great, you know. I just it's not this hard yards of problem solving. It's just write stuff. It's not the soft landing, folks. Be careful. Not the soft landing. Okay, I'm pretty looking for what are you using to support your claims? Okay, so you need to be using material to support your claim. Different sort of material. Okay, no, in this case, we've got legislation, we've got some hard law. We don't really have much case law in this environment. Why don't we have any case law? Because I haven't brought it to your attention? No. Why doesn't it exist? Why do you think we don't have a lot of case law to show you?
It hasn't been much.
Well, that's true, but why? People can't afford it. In terms of tenants, something I probably could have provided, and maybe going forward I'll do this, I could have given you, for example, some tribunal decisions of disputes involving residential tenancy agreements between community housing providers and their tenants, okay? But I'm tending to focus you more on the providers of housing and how that housing is provided overall, and its financing and the legal framework. So the reality here is we have hardly any case law because the providers themselves have not challenged the decisions made by the government of the day. Why haven't they challenged those decisions? Because the reality is the government of the day is funding them, as well as facilitating the work they do in terms of providing accommodation, but it's funding their service. And historically, they've been very reluctant to challenge the hand that feeds. That's the reality. That's the bottom line, folks. So even though, for example, historically, there were commercial leases put in place of a form where community housing organisations were renting out public housing properties that the title was still in the hands of a government agency. But the reality was that there was no dispute over that lease. The rent being offered for this head lease was a peppercorn rent, sometimes $1. Right? $1 for a huge dwelling or whatever, detached dwelling or whatever it was, right? But it was just to enable it to be provided so it could, be used for these purposes. But what was really at stake was what was a funding agreement between the government agency and the community organisation. But that picture has changed with the separation of funding and regulation through the new regulatory scheme that's been introduced and underpinned by legislation. And it's provided greater certainty, greater confidence, and enhanced the appreciation of the balance of rights and responsibilities between all the different stakeholders. It hasn't provided a perfect outcome, but it certainly moved significantly beyond a situation that we had before where, you know, agencies were basically, organisations were dependent on this sort of largesse of government and the funding that they were happy to continue to keep providing organisations for their survival and to do the work they thought was important. Okay.
Michael?
Yeah, Peter. Yeah.
Just, I think too, one of the things that has really forced a lot of change in it in the last 30 years from that public housing viewpoint to more of a community housing type situation, where, and the is the fact that these people got into, you know, a lot of people got into the housing commission properties, and virtually they couldn't force, you know, they couldn't force them out with a landmine, so to speak, and they virtually were having to sort of get more and more and more properties at the public's expense and maintain these properties at the public expense, without to the point where it became absolutely impossible to keep going with it. So they had to sort of try something else.
There was that. That's true. The other thing that had occurred is that the housing stock which had been acquired by the government of the day or built by the government of the day, following, you know, particular models and particular ideologies that existed at the time, basically no longer suited the needs of the changing demographics of the population. Okay. If you go back to some of those policy documents, you'll see that a lot of those that are housed under these programs are the continuing community housing programs, not the emergency programs or the short-term programs or those sort of things. But a lot of them actually continue to address the needs of women, females that don't have other options for a range of reasons, and including with dependents. That still continues to be a large proportion of the housed tenants that these programs, long-term community housing, is reaching out to. But their needs and their circumstances have changed in terms of, you know, what we're looking for, and what they're looking for in terms of both the style of accommodation, you know, reasonable, but style, and its location. And the other thing that we've had is we've moved away from these huge multi-storey complexes that became ghettoised, involving significant social issues and problems for a whole range of reasons. And there's different strategies being developed. So what we've got... Yeah, Peter.
Also, you had there, when this was first introduced and it first was public housing, there were a lot of women who were widowed and left with families. And as those families grew up, and that you ended up with a house that had one person in it, because all the kids had gone, they'd left home, but mum still had the house, and she had the house until she died, but you had another family, say of 6 people, who were looking for things and they couldn't get it. They couldn't move into a house because mum had this house for life.
Yep, and that's a part of the picture that was emerging. So this first question is a more conceptual, policy-focused question, and it was, if this came up, for example, in the exam, then you would be requiring to use policy documents and that I've given to you to you know, respond to the question. Right? Remember, it's important to identify the keywords in the question and keep responding to those keywords and themes. Okay, don't find yourself going off on some tangent. Okay, and so this is getting you to focus on that. And don't forget also that it's important to structure your answer with you know, a clear logical structure. In a policy style answer, subheadings are fine to structure your answer. Okay, and to be systematic, but you need to show evidence. That's important, from different sources, sometimes different types of sources, and of course that you're using in problem-solving questions. And you know, it's good to come up with examples. Just going back to the second assessment, which I'm still grading, but I'm making good progress, folks, and I'm hoping to get them back to you next week. But, you know, it's interesting that in that first question, some students sort of came up with some nice practical examples to try and illustrate what they were trying to say. Very helpful, folks. Very helpful to, if you can present a practical illustration, which helps to reinforce the point you're making. And actually, by doing that, it shows that you've actually got a very good grasp of the material. Okay. And the last thing I'll say just in relation to this question before we move on to the next one is very important always to, you know, produce an outcome. Need to produce an outcome. Okay. If you're advising a client, you advise the client. Which way do you think it should go? Even though the law may be a bit sort of this way and that. If it's looking at a policy question, what should be? What do I advise should be the outcome on this? Very important to be decisive, conclusive. Don't just leave things up in the air. All right, so we move on to the next question. Now, the next question is focusing more on the legal frameworks. Okay, so this is a topic that is about legal frameworks, it's about policy frameworks, about regulation, and so on. And we also have, there's another thing I didn't show you, but I'll just share that with you now. Just find it because I was putting it up beforehand. I get it. Anyway, can't find it at the moment, but, oh, wait a minute, sorry. I'm going to get this PDF doc. Give me 1 sec. Oh, this is what I want to show you. All right, so I'm just going to screen share this. Important to remember that in this area of community housing, so we've got the legislation, but we also have what's referred to as the national regulatory system of community housing. Okay, and I've given you access to the website for the NRSCH. Now, the other thing which interesting is that there was a review done of the NRSCH 2018-2019 in terms of their performance. And you can have a look at that document in terms of, you know, what's happened, where they're going, and just some interesting statistics on performance, okay? Right, and so on, okay? So that's a bit of an evaluation of the current regulatory system of community housing, okay? And I think I've put that on the website, but certainly you can access it through the website for the National Regulatory System for Community Housing. And I think Nicholas has already given it to us. He's quick off the mark, this chap, certainly quick off the mark. That's great. So don't forget that. So let's move on to the other question. The other question is, oh wait. Question is focusing on, just screen share that again for you. All right, so it's focusing on what are the benefits of the enactment of the Community Housing Providers National Law, 1, and secondly, explain the relationship between that national law and we could say the Housing Act Queensland. Okay, so, you know, this question obviously requires you to have, you know, be aware of the national law, aware of its strategies, aware of what it's about, and so on. You may not have gone through all of that, which, you know, I understand timing and other pressures and so on, but it's about a system that's introducing a regulatory framework. It's about setting stronger parameters around the sector. It's about introducing more robust structures of regulation. And it's a national law, but it's not out of the federal parliament. It's a cooperative, it's as a result of a cooperative agreement between state and territory housing ministers. Just in view of that, maybe you drop in the chat box, what are the benefits of the emergence of that sort of arrangement? Does it have benefits to have a national law in that way, that it's not actually federal legislation, but it's as a result of a cooperative arrangement, and it's focusing on regulation and registration processes? And how is that beneficial? Yeah, that's good. And I'll just, you can respond to this maybe. Is it a problem, or is it an issue that it's not actually grounded in federal legislation? And a further dimension is, why are we talking about it as a national law if it's not actually legislation? Is that misleading? Yeah. So Anthony's point, yeah, it's good. Flexibility, that's good. So that's an interesting point by Nicole too. One of the interesting things is that the consequence of having this umbrella national framework is that it then is being incorporated in states and territories as state or territory-based legislation. But it's important to remember that it hasn't been picked up by all jurisdictions. Okay. So, and those jurisdictions that have picked it up are not picking it up in a uniform way. So there are still differences and variations. Now you might say, look, that's as it should be, because something like this, there are variations around the jurisdictions. The picture's not the same. The needs and the strategies are not the same. Queensland, New South Wales, Western Australia, South Australia. The picture, it's not uniform, right, in terms of the situation or the needs and the population and so on. Maybe that's fair enough. It is also about political will, the government of the day, and how they want to deal with it. It's also interesting, some jurisdictions have decided to incorporate it into their Housing Act, which the Housing Act otherwise deals mostly with public housing and the nature of that and the responsibilities of that and so on. Whereas New South Wales, for example, has enacted its own separate legislation dealing with this area, and it's a bit more robust in different ways and a few more different initiatives there. One thing that is certain is that we have, under the national regulatory system, which is embedded within this national law, we have registrars in all the jurisdictions that are ultimately sitting and administering this system. And sometimes they're sitting within government agencies, they haven't got full independence or autonomy. And that can create some issues. But it certainly has ratcheted up the level of accountability and the level of oversight and just the way in which the sector is regulated and administered in a way that is different to even 10, 20 years ago, before the system was introduced. The other part of this question is this is a more drilled down part. So part B says explain the relationship between the community housing providers national, so the relationship to the national and the Queensland Act, essentially. we're talking about the Mending Act, but we're talking about the Housing Act. To adequately deal with a question like that, your response needs to drill down into the legislative provisions. Right? So, for example, if I just share this with you, I'll go back to where are we? To share. So this question would require you to be looking at the provisions within the Queensland Act and the strategies adopted in, and this is just I'm looking at the appendix, which is the national law. So, you know, a response to this sort of question, you know, it doesn't require, you know, a blanket overall coverage, but it requires you to drill down into some of the features, okay, and to compare and contrast. Now, I just want to stop screen sharing that because I want to make an important point. The focus, in something like this, you've got to be selective. So you've got to decide what are some of the big ticket items, you know, and within the context, again, just, you know, in how this is going to be assessed for you if this aspect comes up in the exam. So within the time frame, you might have, you know, say on this aspect, if this arose, you know, you could compare maybe 2 or 3 different areas within the legislation, for example. So you've got to pick and choose. The purpose here is not just to describe. I mean, that's pretty basic, folks. I'm not terribly interested in you just describing. Okay. I need you to analyse and to say something. Just let me say that again. I need you to do some analysis and say something. I need your voice to come through your answer. What are you saying in response to the question? I just don't need a descriptive exercise. So in the exam, for the policy style question, but certainly for all the questions, but for the policy question, take a few minutes, take even maybe, I don't know, if you work out how much time you've got, might take 5 minutes over the course of the time that you've got, or maybe a little bit longer. Think about what is the point you're trying to make. What is the argument you're trying to present in response to the question? How will you be planning to support that with the materials that you're going to use? Okay, so that's what you need to think about. Okay, and it's about being selective, but it's also about being analytical, and it's about saying something in terms of what is the question posing and raising, and what is how are you responding to that challenge that's being presented to you. Also remember the audience that you are being asked to address. Some people in the question 1 of the second assignment seem to forget that. I thought I made it pretty clear that you were giving a presentation to law firm partners. Just giving me an analysis or a discussion about the mechanisms doesn't actually achieve that, surprisingly. You have to tailor it to your audience, and that's part of the exercise. You know, I don't tend to present those challenges just because I've got nothing better to do. I'm actually wanting you to think about different ways of presenting your understanding to different groups, because as lawyers, that's exactly what you'll do. You will not only be advising clients, you may be involved in some policy work, working for the government. You might be actually involved in some, you know, reform work with a community-based organisation, community legal centre. You might be doing a whole range of things. You might be working within a corporate organisation. You know, our work as lawyers is many and varied, folks. Our skills and our talents are called upon by a broad cross-section of the community and the society to do a range of things. And it's our understanding of the legal frameworks, our capability to express ideas and thoughts in the way that we do as lawyers that is what is being sought and solicited from us. But not always is it about just clinical legal advice. That's why it's important for you to test these different communication skills, which is, I think, is important, through different mediums too. Media, that's why options with regard to multimedia presentations and so on. Many students have taken up that option and have done some really nice presentations, which is excellent. Others have done text-based responses. This is question 1 of the assignment, and some of those were very good too. But you're encouraged to be innovative. I always want to encourage you to be innovative wherever possible. Okay, so that's really all I wanted to say in regard to that topic and those questions. This is a topic, just reiterate, this is a topic that's on the exam. It's in part A, which means it's policy style question. And the question will be, and the mark allocation will be more than was in the term 1 course. That's the property law course, Foundations. So you have a bit more to chew on, if you like. And I've given you some additional materials around that. That's for this topic and also the other topic that's assessed. And as Nicole's asked me to put up a response in terms of that earlier topic that's assessed in part A2, and I'll do that for folks. But again, remember that's policy style, not problem-solving style. That topic's being assessed, earlier topic. So there we are, people. Social, community, and affordable housing. It's an important area that's emerging and evolving, and it is an area that really needs access to lawyers that are skillful, that are compassionate, and have an awareness of the particular issues and concerns of this sector. So I want to encourage you to think about that going forward, both, just think about it generally, of course, in terms of your studies with me in the unit, but going forward, it is something that is an area where you may consider leveraging yourself more into in different ways, because there's certainly a need in the community for, in my view, good lawyers that can provide legal advice, guidance, involved in policy work, involved in reform in this evolving environment, dealing and responding to the property and property issues that are relevant for, all of those stakeholders in this environment, government, community organisations, and ultimately those that have challenges, social, economic and cultural, in getting access to more conventional accommodation and housing.
I think I think you made that quite clear, Michael, in your actual Law Journal article from 2017 that you happened to put up there. I did actually read it. Not the brown nose, but I did read it. And it's interesting because you also put up that image from the Housing Assistance in Australia 2016 report where it said there'd been a 50% increase between 2009 and 2015. If you have a look at that National Regulatory System report that just came out, there's some more data in there. I'd hesitate to believe that over the next few years, we're going to end up with a hockey-style stick curve in the amount of people that are going to need assistance in this area. And I think it's going to grow, and it's going to grow rapidly.
The other thing too, Nicholas, and thanks for that, and there's a range of materials being put up, and Anthony actually, who unfortunately doesn't join us because of any commitments, but he's put up the 2019 government service report under the in one of the Moodle links, and that even gives more recent data from the Commonwealth's perspective. But the other dimension that's going to change the involvement of lawyers in this space is issues around title and who can have title, so that it's not just about residential tenancy issues. It's not just about advising on sort of issues that were really about executive government decision making, but this is now much more concretised in terms of legal agreements, the sort of things that lawyers get involved in, and increasingly, in my view, the sort of things that property lawyers, innovative, creative property lawyers get involved in and need to be involved in. So, and I agree with you, Nicholas, that I think this is an enlarging area of need, not a diminishing area of need, as housing becomes more and more expensive and difficult for people to access in a range of ways, in a range of situations. So there we are, folks. There's topic 8, social housing. Now, Nicole had raised a question about an earlier topic, leases, I think it was. Is that right, Nicole? You still there, Nicole? Yes, no? Is Nicole still there? Nicole, yes? Oh, okay. No. About remedies. I don't know whether we can... What I want to do, look, the first thing I want to do is just take a little break. I'll get a cup of tea. And then we might come back for a short half hour. And if you've got any questions, I can field those. And then I also want to just propose something for next week, which might see what people feel about that. So we'll just take a short break for about 5 minutes or so. I'll just make a cup of tea and then we'll come back and we'll have a short Q&A about any issues that... Oh, okay, that's good. Good. That's good. So hopefully helpful strategies rather than unhelpful strategies. I always try to do that. Yeah, good. I've tried, I mean, it's sometimes hard to strike the balance, but I think one of the things that I have become more conscious of is that it's important to get clarity around some of these difficult, challenging areas. And I think it's also like we need to get some discussion happening, that's clear. But I also need to, important to remember many of those students who can't attend class, in real time. And yeah, that's right. I agree with that. Good points. Those who can't attend in real time, and so they're probably finding, the explanations hopefully a bit more helpful as well, rather than just the open-ended chat. So getting that balance right, really, at the end of the day, I think that's the reality. So we'll just take a 5-minute break, folks, and then we'll come back in and we'll have maybe a half-hour Q&A. Nicole's got a question. Other people might have a question, and then we'll do that. Okay. So see you in 5. I won't turn the recording off. I'll just pause it, and we'll come back in 5 minutes. See you then. Here we go. Thanks, Nicholas.
We'll do it all again, and you can ask us those questions, and we'll just jump in straight away.
No, what I'm going to do is I'm going to do a quick summary. Okay, so you've had the benefit of that exegesis, right? Now I'm going to do a quick summary. So the point is, we've just been talking about. The question was posed. We're now in the Q&A session, folks, and the question was posed about access to remedies where there is a dispute regarding a lease. Can you get access to both proprietary and contract-based remedies? The response is you can argue both, but it depends on the circumstances of the party you're advising in terms of what's most appropriate. The proprietary relief will essentially be about access to the land, where the landlord will be seeking to recover possession. The lessee will be seeking to resist that and hold on to possession and to maintain their leasehold interest, and maybe find ways or be allowed to address the breaches in a way that's acceptable to the other side. But so that's an argument around possession, if you like, in terms of the proprietary relief. Contract-based remedy is in looking at getting access to common law damages, which is financial compensation. What is that? It's grounded in the fact that there's an argument about that there's been a loss of bargain. So what I'm just turning back to in the case book to look at this in terms of the issue around remedies, you can see that this is discussed starting on page 809 of your case book, right? And we've been through those, mentioned those cases before: Progressive Mailing House and Tabali, quite important; Gumlin Property, quite important. So for example, just in terms of Gumlin Property, you can see, I'm looking at page 818, and there's a reference back to Mason in Progressive Mailing House by the court in Gumlin Property, right, which was also the High Court. So this is what they said, okay? Mason said, contradicting the lessee's submission, that it cannot be said in the case of repudiation or fundamental breach, as he defined it, including breach of a condition, that loss of the bargain is attributable to the innocent party's exercise of his contractual power to terminate. It is different in the case of termination for non-essential breach, as Sheville demonstrates, because by terminating pursuant to the contract at that stage, the innocent party puts beyond his power to insist on performance, thereby bringing to an end any possibility of repudiation or fundamental breach with consequential damages for loss of bargain. So the other aspect which is important in terms of accessing the contract law type remedy is, well, what type of provision, what type of covenant, what type of term in the lease are you arguing has actually been breached? Is it a fundamental term of the dealings between the parties? Is it a somewhat of an innocuous or inconsequential provision? We're needing really to say that it's something fundamental, okay? And payment of rent can be seen in those terms, even though it's not characteristic of a lease, but it can be fundamental to the agreement between the parties. So that's what's then enlivening this idea that there's been a loss of bargain, and then will give us access to those types of damages. But in terms of deciding which of those, you can often argue them together, but what's more appropriate in terms of what the circumstances of the client you're advising, lessor or lessee, is, and what they're ultimately seeking. Are they looking for some sort of financial compensation because they say there's been, some fundamental breach, or are they looking to actually, pursue a remedy in possession to retake possession or to hold on to possession? And don't forget also that the landlord has the right to forfeit the lease. So there's a proprietary right to forfeit the lease to get access to recover possession. But the tenant or the lessee can actually seek to get relief from forfeiture, which will mean to resist that forfeiting by the landlord. So the remedies dimension here is important, but it's also a little bit complicated. And there's two ways that you can get access to these remedies. And it really very much depends on the circumstances of the case, what the parties are looking for, depending on who you're advising, and whether we're seeing that we've actually got a fundamental term being breached or something inconsequential, or whether the parties are really concerned about getting possession, either taking it back or holding onto it.
So that issue of fundamentality or consequentiality is really looking at a utility of hierarchy, isn't it, when it comes to the issue at hand? So you need to be looking into the specific issues in regards to what's being posed by either party, and then look at that from a hierarchical point of view. That's what it seems to me from that judgment you just read out.
When you say hierarchical, what do you mean by that, Nicholas?
I mean that there's a utility in hierarchy, in the sense of that some objects within the structure have more presence or more consistency of power than others, in the sense that they need to be looked at first because there is more potential damage or inequity to one party over the other if they are not put in that hierarchical area.
Oh, okay. Yeah, okay, that's fair enough. I understand now. So, yeah, I think that's a fair point to make. The other thing too, folks, is it's really important to understand the consequence of enforcing upon the proprietary outcome. So if in fact the landlord can recover possession, which they might be seeking to forfeit the lease, that has potential dire consequences upon the lessee. Basically, it's tossing them out, right? Now, don't forget, we're not talking here about residential tenants. I mean, it's pretty dire for a residential tenant to be evicted. But we're talking about a business here. So if someone's running a business and they're suddenly being tossed out of the premises, their entire livelihood may be at stake. Right, and there might be legitimate reasons for that action being brought by the lessor, breach of covenants, a range of covenants, including non-payment of rent, for example, right? But it's a fairly drastic remedy, and that's why the courts have identified, and particularly equity has identified, relief against forfeiture, even in the proprietary environment of remedies. But then again, we have these contractual remedies as well. So the picture is a bit more complicated, as I said before, and it's not just an either-or scenario, but it's really, working with the facts, working with the situation to see what's best. And also the other point that we didn't touch on is that, do the parties actually want this lease to continue, or do they want to terminate the lease? Does the landlord want the lease terminated, or is the landlord happy to work with the situation to allow the lessee to continue, to allow the lease to stay in place, and to have the breaches remedied and addressed in the way that might be acceptable to the landlord, as opposed to that more drastic action of recovering possession?
Well, if you provide us with the question for the exam now, Michael, we'll be able to give you a succinct answer, won't we?
You're always trying it on, aren't you, Nicholas? I like that. But look, I just want to emphasise, for the benefit of all of you and also all of those listening to the recording, that we've spent 2 weeks on this unit, on this topic of leases. It's an important area. It's assessed in the exam and in the problem-solving questions, and you need to have a good grounding in that topic, okay? And can't say more than that, really.
I know we spent 2 weeks on that, Michael, but in all absolute reality, when I've looked at the amount of reading that there is for this week and the amount of policies and there's just as much potential reading and cognitive understanding that needs to go into this week's material as there was for the previous 2 weeks. So either or policy question is going to be exceptionally difficult. Well,
except that, there's 150 pages of the casebook on leases. It's not exactly 150 pages of materials in this. And look, I want to clarify that on the website for this topic, there are some additional international materials that I've provided you with. They are not essential reading. I've pointed this out, I think, in an email to all students. Not essential reading. So I've given you some materials from the US, for example. Just there's something additional to show you the developments that are taking place elsewhere, but not essential reading and not essential for tackling the exam questions, but just there to show you what's happening in other places, particularly in the US and so on. So I'll just point that out. But yeah, I acknowledge that, there's challenges and an array of material in different ways. Yep.
Well, I just believe personally the social housing policy question would be a little bit harder because, as you clearly stated, you have a factual interest in that material. So if we make a mistake in answering that question, you're more than likely to pick it up a lot easier or quicker than you may be the first question.
Well, I've got a fairly good grasp of most of what I talk about, hopefully. But I do have an abiding interest in that topic. But I'm not churlish with students in terms of, you know, I mean, I'm looking at what they are giving me, you know, in your answers, and I am rewarding you on the basis of what is there. Okay, so, and I'm open, certainly open to what you are prepared to give me in responding to the challenges that present on the exam paper. Okay, so any other questions about other areas that you'd like to toss up at the minute? I'll just come back to Nicole and to, is Eve still there, or Eve's gone maybe? I'll just
she's still there. She's gone quiet. It's unlike
all right. Just no. Is that? Are you happy with? Is that happy with that response, Nicole? Is that okay? Or Eve?
Yes, I think that's answered our question, hasn't it, Eve?
I think your counsel is departed the scene. But you seem to be okay with that. Okay, that's good. Yep. Good. Now, yes, Sarah's point. Yes, I'll put up a practice paper shortly for you. Sorry about I'll get that up shortly. Yep, absolutely. By Monday, absolutely, or maybe even before. And the other thing I'm going to do is I will also going to be uploading. I'll do a recording, an information recording on the exam, just to tie up some of these points of clarification that I've provided for you in the way that I have for the other assessments. Yeah, so I'll do that and get that up shortly too, by early next week. Any other questions? Just checking since I'm wrapping up. Yeah, that's fine. All good, Sarah. All good. All right? All good. And any other questions? I've got one thing that I just want to ask you before we sign off tonight. But anyone else got any other questions you'd like to pose at this time? Well, it's not about length, you know that. It's about quality of response. That's probably usual from this side of the table. All I can say is you know, it'll be higher, more marks, not that many more marks, but a few more marks attached to the policy question this time than was in the term 1 unit. So you'll be able to spend a little bit more time on it. Thought that was warranted, given the style of the questions, and that, you know, there's a requirement there to think about the question posed, but also to think about some of the reform initiatives and so forth, and the material that I've brought to your attention. So it's not about length, but it's about, you know, I would say to you, the main thing is you just need to be clear about your allocation of time, and that you stick to that. Okay, so that's and you'll see that from the mark allocation of questions, mark allocation per questions. Yeah. Any other questions at the minute? Everyone's gone quiet, worn out, I think. All right, so what I wanted to pose to you is this. It's clear from my instructions, exam instructions, that the last topic on the law of mortgages is not assessed in the exam. Okay. We certainly still need to cover it, you know, it's part of the unit, and I want to do that. But rather than running it over into, you know, the next 2 weeks, what I was maybe thinking of doing, and I just want to get your thoughts on this, is this is week 10, so we can think about the possibility of maybe covering both topics 10 and 11 next week, with a short break in between, and then that will mean that we can focus in the last week, week 12, on exam preparation and exam review. So how would people feel about that?
I wouldn't mind either way, Michael, as long as we cover easements probably more in detail than mortgages, since easements is going to be on the final exam.
Yeah, of course, that's absolutely true. So a full class on this is what I would be proposing, basically. Okay, so as I have decided we're not going to worry about more. I think we've done enough on mortgages. We haven't really fully explored the law of mortgages. I know that, but I've given you quite a bit of material, and we've had quite a bit of focus on mortgages in assessments and so forth. And I just thought, well, we don't need more on mortgages. That's the reality. Right? So what I would be proposing is have a full regular class on easements, doing the problem questions discussion in the way that you seem to have, several of you have suggested is helpful, and then have a short break, and then I just need to get my head around the other material, need a short break, and then come back in, and then I basically will just give an overview of mortgages, deal with the questions. We don't really need to go into a huge amount of depth on them, and address it like that. And then that means we will have tied up the course at the end of next week, and then that will leave week 12 to focus on exam review and preparation and discussion, and also you can then just focus on that as well going forward toward the exam, which I think is still on the 21st. Is that right? Exam still on the 21st?
Yeah, as far as I'm aware.
Yes, good. Okay. So is everyone happy with that approach? Everyone's got, I think, yes, nods, yes, good, yep, okay, good. Okay, well, we'll aim to do that, okay? So, there we go. So the class will be a bit longer next week, but that means we'll just tie everything up, and then we can, from then, you can just then, from the end of week 11, you can then just focus on review and exam preparation, which I think is appropriate. And I am hopeful, very hopeful, and have full expectation of getting your second assessments back to you next week, making very good progress on those. I've been making comments to you and so on, so you can, quite clear that I've made a fair bit of progress on those. So have that done and dusted too. Okay. So.
Good night from me.
And it's good night from him. There we go. That's a two-person act. So enjoy your week, folks, and we'll see you next week for the last topic on the last substantive class on land law in terms of topics. But week 12 will be exam prep and exam review, and we'll do something special in week 12. I always do something a bit special in the last class. So enjoy your week. Bye for now.